Hello and welcome. My name is Krista Kartson, and I'm the VP of Community Building and Engagement at Welcome.us. This event is hosted by Welcome.us, and we are a nonprofit, non-government organization founded in 2021 to equip and empower Americans to participate in the work of welcoming newcomers. This is a special edition of our webinars that we're recording on October 2nd, 2025, in response to questions we've received from Uniting for Ukraine or U4U sponsors regarding legal pathway options, including re-parole, temporary protected status, and asylum for Ukrainian newcomers. We've bookmarked this video by question, so feel free to skim the bookmarks and skip ahead to the topic that you're most interested in. We've also provided links to referenced resources in the video description. And today we have the privilege of being joined by Anne Smith, Executive Director and Regulatory Counsel for the Ukraine Immigration Task Force, to address your questions and provide expert guidance. Anne, thank you for being here.
Thank you for having me.
Let's start off with questions. We've heard from a few sponsors recently that some Ukrainian newcomers have received approval for re-parole. Can you tell us more about these cases and who it applies to?
Sure. So first, I want to remind everybody that the responses I provide today are for informational purposes only and do not constitute legal advice. I cannot discuss strategies for specific cases, but I will try to provide the current regulatory and procedural context. As always, I urge those with legal questions to consult a qualified immigration attorney. So with that out of the way, I will talk a little bit about what's happening with Ukrainian re-parole. The good news is we're finally seeing a number of re-parole applications after a period of inactivity and a month or two of denials. This is encouraging news, and we are hoping this trend continues. I am currently trying to get an estimate of how many approvals have been issued, but as of now, the official data from USCIS is only available through June 2025. That data aggregates humanitarian parole applications for all populations, including those filed from abroad, so we're not able to discern how many Ukrainians have been granted re-parole. From what I'm hearing anecdotally, it sounds like USCIS is now processing up to 150 or possibly more re-parole requests per day. That doesn't mean that everyone is getting approved, but we are definitely seeing a promising number of approvals. However, we are also still seeing some denials here and there. Additionally, some applicants are receiving requests for evidence after they file for re-parole, which is not unusual in traditional parole adjudications outside of parole programs. So with the somewhat limited data we have, primarily from our attorney network, it's too early to report on patterns, but so far, the anecdotal evidence points to a fair amount of randomness in terms of decisions and processing speed. So while re-parole applications seem to be moving through the pipeline, a lot of applicants remain in limbo with long delays, and that is frustrating. So we are telling parolees not to get too anxious if they haven't received a decision yet. It doesn't necessarily mean that there's a problem with their application.
Thank you, Anne. So what guidance would you give U4U sponsors who are applying for re-parole? What components would you recommend they include in that application?
So I'll briefly run through the required documents, then provide some suggestions for additional statements and evidence that applicants may want to include. To apply for re-parole, applicants will need to file Form I-131, application for travel documents, parole documents, and arrival departure records. With their Form I-131, applicants will need to submit the following documents. First is evidence that they were previously paroled into the United States. This can be their Form I-94, which can be obtained on the CBP website. They can also submit a copy of both sides of their USCIS issued Employment Authorization Document, or EAD, that was issued on the basis of humanitarian parole. Next, applicants will need to submit an identity document with their photo, name, and date of birth. This can be a copy of both sides of their U.S. government-issued driver's license or other U.S. government-issued ID. Alternatively, they can submit a copy of the identity or biographical page of their passport and copies of all admission and parole stamps in their passport for entries into the United States. Children may be included in a parent's Ukrainian passport. In addition, applicants will need to submit a statement explaining the urgent humanitarian reason or significant public benefit for a new period of parole. So that means re-parole. They also need to submit evidence that they personally warrant a favorable exercise of discretion to be granted parole. And applicants will need to submit a statement explaining why a U.S. visa or other immigration status cannot be obtained, including when and where attempts were made to obtain a visa or other immigration status. Applicants will also need to state the length of time for which parole is requested and why the previously authorized time frame for parole is not sufficient to accomplish the purpose of parole. And finally, they will need to provide evidence that supports the basis for their re-parole request. And in addition to the above requirements, applicants may want to consider providing additional elements in support of their re-parole request. USCIS allows them to upload further documentation by selecting unsolicited evidence in their application portals.
Thank you, Anne. What are those additional elements that folks might consider submitting as part of this application?
Some applicants may consider drafting a cover letter addressed to the attention of USCIS officer or a personal statement with some or all of the following components. These could be an introductory statement that they are writing to request re-parole and for how long, the type of urgent situation they are facing, a more detailed explanation of the urgent humanitarian reasons for why they cannot return to Ukraine, such as critical medical necessity or grave risk of imminent risk of violence, persecution, and death. They could also consider submitting new evidence or documentation reflecting the ongoing urgency of their situation, such as updated medical records, new threats to their safety, or other evidence showing their need for parole continues. They might also want to provide a brief explanation of any family ties they have in the United States, if applicable. Also, a brief statement of how their presence in the United States would benefit the public, such as provided needed skills or expertise, if applicable. They could also provide a statement that they probably should provide a statement that they maintain continuing ties to Ukraine, for example, through family, property, or employment, and that they intend to return there. They can also provide a bulleted list of attached documents, such as medical records, evidence of threats, country conditions, media reports, financial documentation, and other evidence, as well as certified translations of any documents in other languages. It also helps to have a statement explaining their ability to support themselves financially for the duration of their stay in the United States. If they cannot support themselves, it may be helpful to provide a letter from a financial supporter or organization that has agreed to support them, along with the supporter's financial documentation. And finally, they can finish with a brief summary requesting a grant of re-parole, a reiteration of the urgency of their situation and why they need re-parole, their willingness to comply with any conditions imposed by USCIS, and their hope for a favorable response to accomplish those stated goals or receive the necessary relief or assistance. And this can be followed by a closing statement thanking the officer for considering their application and providing their contact information.
Thank you, Anne. So when newcomers who are here on humanitarian parole through Uniting for Ukraine, when they fill out that form I-131 that you mentioned, which type of re-parole should they be applying for?
When applicants file Form I-131, they are asked to select the basis for their re-parole. Ukrainians can select either Ukrainian re-parole by checking box C in question 10, or they can request a new period of parole not under a specific program or process by checking the box in question 11. Since the official re-parole guidance for Ukrainians has not been updated since October 2024, we don't have a definitive answer as to which basis is more advantageous. Previously, we saw approvals and denials under both bases. We are continuing to see approvals now under both bases, and now we're seeing enough approvals under Ukrainian re-parole to feel comfortable about its efficacy. So I would say, unless there are individual circumstances that affect a parolee's eligibility for Ukrainian re-parole under the 2024 published guidelines, there isn't necessarily a reason to select re-parole not under a specific process. With that said, it bears mentioning that all parole and re-parole programs remain indefinitely suspended as of January 2025, including Uniting for Ukraine. Moreover, it is the current administration's policy to only grant re-parole on a case-by-case basis. Accordingly, there is no guarantee of success through either method, so we always encourage parolees to seek legal counsel to determine the best strategies for filing their individual re-parole applications.
That makes sense. Thank you. You mentioned a lot of different pieces of information that folks might include in that re-parole application. Can you tell us more about what factors does USCIS consider when determining whether to grant that re-parole?
Sure. So USCIS requires applicants to show that number one, there are continued urgent humanitarian reasons or significant public benefit for them to be issued a new period of humanitarian parole, which we call re-parole, and number two, that they personally warrant a favorable exercise of discretion, so a new period of parole that would allow them to remain in the United States. USCIS clarifies that applicants do not need to demonstrate that the urgent humanitarian reasons or significant public benefit are unique to their situation, but they must establish that their direct relevance to the applicant's circumstances. USCIS goes on to say that evidence of general conditions in their home country will not suffice unless the applicant clearly shows how those conditions impact them personally and why they require additional time in the United States. While USCIS does not define which situations are sufficient to warrant a grant of re-parole, they have published some common reasons for requesting humanitarian parole, which can be found in our re-parole guidance. Some of the urgent humanitarian reasons for requesting parole include medical conditions, needing to receive medical treatment in the United States, needing to care for or provide support to a seriously or terminally ill relative in the United States, requesting parole for children, reuniting with family members in the United States, and protection from targeted or individualized harm. USCIS also lists the type of evidence that applicants can submit in support of these reasons.
Fantastic. Thank you. You mentioned Ukraine Immigration Task Force guidance a bit ago. Can you tell us more about what the guidance you're providing?
Sure. Our task force recently published comprehensive guidance on the re-parole process, which can be found on our website and in the video description. It's titled Applying for Re-parole, Updates and Recommendations for Ukrainian Parolees. This guidance summarizes the key requirements, eligibility, fees, and instructions for requesting re-parole. It also suggests other components that may be helpful to include with the re-parole application, including personal statements and documentation. We share some of the more widely recognized grounds for requesting re-parole and list the types of evidence that USCIS looks for. Finally, we discuss a couple of ways to expedite an application that's been pending for a while, and we briefly run through the process of renewing employment authorization.
I see. What is that expedited process? Like, what should a sponsor do if their Ukrainian newcomer applied for re-parole but hasn't heard back?
Unfortunately, this is not uncommon due to widespread processing delays. And that issue has been exacerbated by USCIS staffing shortages. I am told that there is a 7-month delay with re-parole processing, and even applications filed in 2024 are delayed. Moreover, some applicants are being granted re-parole even though their parole has not yet expired, while others are waiting for decisions long after their parole has expired. And there is no way to know whether those who wait a long time will be approved or denied. Some Ukrainians are finding success with filing expedite requests directly to USCIS. The results are somewhat random, though. There are parolees that get a re-parole decision after one expedite request, while others submit multiple requests but don't hear anything. So USCIS may expedite Form I-131 if it meets certain criteria, but it is important to understand that USCIS already considers parole to involve an urgent humanitarian situation by its nature. So those seeking to expedite their re-parole application will need to show a truly compelling reason to justify the expedite request. This is especially true if the pending application is still within what USCIS considers to be normal processing times. To file an expedite request, applicants would likely need to show either severe financial loss or an urgent humanitarian situation. Severe financial loss could include job loss or loss of critical benefits. Parolees who are supporting children or other dependents may provide this information as well. An urgent humanitarian situation could be an illness, disability, death of a family member or close friend, or extreme living conditions. Individuals with pending applications whose parole has already expired are strongly encouraged to submit an expedite request if they're eligible. Some Ukrainians have also had success with engaging their members of Congress to get things moving on their applications, especially if the sponsor or beneficiary has sympathetic congressional staff in their district. It helps to have a compelling personal story since congressional offices are pretty slammed with these requests.
Thank you, Anne. In some of our other webinars this year and our guide for navigating alternative legal status, we've encouraged newcomers and sponsors to explore Asylum if that's something they're eligible for. Can you tell us, is Asylum still a viable option for Ukrainians who meet the requirements, and what factors should Ukrainian newcomers consider in making that decision?
Some Ukrainian parolees could consider applying for asylum. Asylum is a humanitarian protection granted to individuals who cannot return to their home country due to past persecution or a well-founded fear of future persecution because of their race, religion, nationality, political opinion, or membership in a particular social group. Applicants must be able to show a nexus between the harm they suffered or fear that they will suffer, and the relevant protected ground. Many Ukrainians ask us if they should apply for asylum. First, I want to stress that an asylum claim is highly individual and fact specific. It strongly depends on a person's unique history and circumstances. For this reason, it is not possible to make broad generalizations or assess a potential asylum claim without properly interviewing potential applicants. Speaking generally, asylum is a difficult case to pursue, and the chances of asylum actually being granted for any applicant are on the lower side statistically. The outcome depends not only on the merits of the applicant's case, but on the discretion of the asylum officer or the immigration judge for those who are seeking defensive asylum. Some individuals have better chances than others based on their unique story or the strength of the evidence they can present. But I just want to underscore that fleeing war or violence is not by itself a sufficient qualification for asylum unless the applicant meets the other eligibility requirements. An applicant must be able to demonstrate that she or he suffered or will suffer persecution if returned to Ukraine. And the persecution must be significant, such as unlawful or political detention, torture, violation of human rights, physical violence, or some type of severe non-physical harm. The applicant also needs to show that the reason for the persecution is because of their race, religion, nationality, political opinion, or membership in a particular social group. Also, it is important to understand that the persecution must be inflicted by the home country's government or by an entity that their government is unwilling or unable to control. This could present a challenge for many Ukrainians due to Ukraine's general perception by the US State Department and many human rights organizations as a fairly tolerant government. With that said, there could very well be individuals in Ukraine who have experienced significant persecution because of their race, religion, nationality, political opinion, or membership in a particular social group. This could have been at the hands of local government officials where they lived or officials in various administrative positions of Ukraine's government. Another possibility is that some Ukrainians experience persecution because they lived in areas occupied by Russian forces or mercenaries. Others could argue that their race, religion, nationality, political opinion, or membership in a particular social group exposes them to a legitimate risk of future persecution in an occupied or targeted territory of Ukraine. The best thing to do is to speak with an experienced immigration attorney who handles asylum cases to determine if a prospective applicant's asylum claim is worth pursuing.
Absolutely. So, if an individual believes they do qualify for asylum, what is the deadline? You've already expressed to seek legal counsel. So, what would be the deadline that they should be considering? And what are some of the other considerations throughout the process that they might need to know about?
So, individuals who are not in removal proceedings may apply for affirmative asylum to USCIS. They must do so within 1 year of their arrival into the United States. However, those who have maintained valid humanitarian parole, TPS, or another immigration status may qualify for an exception to the 1 year filing deadline. It's important to know that effective July 25th, 2025, there is now a $100 initial filing fee to apply for asylum, and that went into effect for applications filed starting October 1st. There's also a new annual asylum processing fee of $100 per year for those with pending asylum applications. Asylum seekers are eligible to apply for employment authorization 150 days after they filed their asylum application, with limited exceptions. The fee for a first-time work permit as an asylum seeker is $550. According to regulations, a work permit for asylum seekers is supposed to be issued within 30 days of filing Form I-765 to request the employment authorization document. But practically speaking, asylum seekers are facing major delays in processing their EADs due to a massive backlog of applications. Once they finally receive a work permit, it will be good for 5 years and can be renewed. Those who are ultimately granted asylum may apply for a green card. As I mentioned, asylum is a long and uncertain process that typically takes years. While having a pending asylum application does not confer a lawful immigration status, asylum seekers are permitted to remain in the United States while their application is pending. However, the fact that they have a pending asylum application does not insulate them from the threat of immigration enforcement. More information about asylum for Ukrainians can be found in our article titled, "Can Ukrainians Seek Asylum in the United States?" which we've included in the YouTube video description.
Thank you, Anne. For those Ukrainians who might not qualify for asylum, are there other pathways they could consider applying for?
One short-term protection is temporary protected status, or TPS. TPS allows individuals to temporarily stay in the United States while their country is experiencing conflict, disaster, or other extraordinary conditions. TPS is not viewed as a full immigration status, but rather provides protection from removal from the United States while allowing individuals to apply for employment authorization. Ukraine was first designated for TPS in 2022, then redesignated for a second term in 2023. In January 2025, the previous administration extended Ukraine's second TPS term, which had been set to expire in April 2025. The extension period now runs through October 19, 2026. Ukrainians who apply for TPS and are approved will be allowed to remain in TPS status and apply for employment authorization through the end of the extension period. As of now, Ukraine has not been redesignated for a third TPS term, which would have opened eligibility to a new pool of applicants. So the eligibility requirements remain the same as they were for the second term. To qualify for the current term, Ukrainians must have arrived in the United States on or before August 16, 2023, and have been continuously residing in the United States since that date. Ukrainians who were previously granted TPS that has expired may also file a new application for the current TPS term. Initial TPS applications will be accepted throughout the extension period. However, Ukrainians who filed after April 19, 2025, or who plan to file in the future, will be considered late filers. So they will need to meet one of the late filing exceptions and submit a letter of explanation to USCIS as to why they're filing late. While their applications are pending, applicants are allowed to remain in the United States. According to USCIS policy, at least in previous years, individuals who file a prima facie eligible TPS application, meaning they meet all the legal requirements on paper and file a complete and truthful application, will not accrue what is called unlawful presence if their application is later approved. However, it is important to point out that a pending TPS application does not by itself confer a legal status and does not protect against immigration enforcement.
So helpful. Thank you, Anne. Can you tell us a little bit more about who is actually eligible for TPS?
So TPS is open to nationals of Ukraine or those with no nationality who last habitually resided in Ukraine. TPS is not open to individuals who lived in Ukraine but do not have Ukrainian citizenship, which is an issue for some parolees and mixed citizen families. On the other hand, TPS is available to individuals who hold both Ukrainian citizenship and another country's citizenship, though they may be subject to higher scrutiny by USCIS to determine their operative nationality and rule out any firm resettlement bars in other countries. Generally, TPS is open to individuals with any immigration status or lack of status, except lawful permanent residence. So Ukrainians who have expired parole are still eligible to apply for TPS. However, those who have been convicted of any felony or two or more misdemeanors committed in the United States, as well as those who have been arrested, cited, or convicted of a crime, are strongly advised to speak to an immigration attorney before applying for TPS, as there could be extra steps or waivers involved. More information on TPS in Ukraine can be found in the article titled Temporary Protected Status is extended for eligible Ukrainians who arrived by August 2023, also in the video description.
That's so enlightening. Thank you. Can you tell us, are there any other potential avenues for folks who arrived through Uniting for Ukraine who might not qualify for TPS or the other pathways that we articulated this afternoon?
Sure. So, for those who don't qualify for family based immigration, which unfortunately is a number of Ukrainian parolees, one potential avenue could be the diversity visa lottery. This program is overseen by the U.S. Department of State and provides a pathway to a U.S. green card for individuals who would otherwise have limited options for permanent immigration. Unlike family-based immigrant visas and most employment-based immigrant visas that require a U.S. sponsor, the diversity visa lottery allows individuals to self-sponsor themselves for a green card. The 2027 diversity visa lottery is scheduled to open in early October 2025, and applicants can enter the lottery through early November. A number of Ukrainians have won the diversity visa lottery in the past few years, and some of them have gone on to apply for immigrant visas, then green cards through this program. More information can be found in our article titled Diversity Visa 2027 Green Card Lottery to open in early October 2025, which is linked in this description.
Thank you, Anne. Are there any employment-based pathways for Ukrainian newcomers?
Under the current legal framework, humanitarian parolees are not eligible to seek green cards through employment-based immigrant visas without departing the United States. While an employer may file a petition to sponsor a Ukrainian for an immigrant visa, Ukrainians who entered on parole are excluded from filing for adjustment of status from within the United States on the basis of an employer-sponsored visa. They must either apply for a green card through a U.S. consulate abroad or attempt to adjust status after returning to the United States on TPS status. The latter option requires a grant of TPS and a TPS travel document. We have some guidance on this topic on our website in the article titled, Can U4U Humanitarian Parolees Apply for Employment-Based Permanent Residence or Green Cards, which is linked in this description. Likewise, humanitarian parolees are not eligible to pursue non-immigrant visas, such as student visas, temporary worker visas, or visitor visas, without departing the United States and applying to a consulate abroad. Note that parolees should exercise extreme caution when traveling abroad. There is a risk that they will not be paroled back into the United States, even with an advance parole document. Unless they are later approved for a visa, they may not be able to re-enter the United States after they leave.
So important to note. Thank you, Anne. Can you tell us more about where can U4U sponsors and newcomers go to access more information from the Ukraine Immigration Task Force?
So we have a number of resources on our website, www.ukrainetaskforce.org, and it is listed under our news and events tab under the legal updates, and also under the resources tab under resources in the United States. We also tend to provide a lot of more timely updates on our Facebook page, which is, I will tell you in 1 second, facebook.com/ukraine.immigration.task.force. And likewise, any upcoming events or training webinars are likely to be posted on our Facebook page. And we also have a community distribution list where people can receive periodic updates on some of the more major developments in immigration law that affects Ukrainians. And if you'd like to join our community distribution list, you can email us at communications@ukrainetaskforce.org.
Fantastic. Thank you. That resources page has been such a tremendous resource for me as a U4U sponsor in the last few years. And I'm definitely going to sign up. I'm going to email that email address, communications@ukrainetaskforce.org, to subscribe to your list as well. And so thank you, Anne. You've been such a wealth of information for us throughout the years and particularly just in this moment. So I want to thank you so much for taking the time to address these questions and to provide guidance for the sponsors who've been so dedicated to the Ukrainian newcomers we've welcomed. And as things change, welcome.us, alongside Ukraine Immigration Task Force, continues to be a center of gravity for welcomers across the country to find belonging, connection, and resources. To our sponsors and our welcomers, I hope you found that to be the case in this webinar today. Thank you for your time and be well.
And you too, Krista. I just want to thank you and your team for your tireless work over the past few years and for collaborating with us to provide so many webinars and resources that really help reach a much larger audience. And I also want to thank your generous and selfless sponsors for continuing to support Ukrainians in their great time of need.
Thank you.